across the globe. This is Focus on Liberia. This is a special edition of Focus on Liberia. We are discussing some current issues as they unfold in Liberia. And our guest tonight is a member, an executive member of the Liberia Bar Association, National Bar Association, Councillor Kunkunyon Wleh. Councillor, no, Attorney Kunkunyon Wleh. Attorney, welcome to Focus
Yes,
on Liberia.
yes, sir. Thank you, Mr. Jar.
All right. And to all our guests across the globe, please, Tony, invite someone and let's dive into it. Before we start, I want to, with sadness in my heart, this is a tribute to my brother-in-law, that's the older brother of my wife, Mr. Sam Minde Wleh Jr. He passed away this week, and our hearts are with the family. So, easygoing brother-in-law, we say sleep well, and this entire show tonight is dedicated to your memory. Well, attorney, there are a lot of things happening in Monrovia, legally, or some legal issues. And I want us to delve into them, but before that, I want to introduce you as an executive member of the Liberia National Bar Association. Attorney Kunkunyon Wleh is also a partner at International Law Group Incorporated in Monrovia. Attorney, welcome.
Yeah. Thank you, Mr. Jar. And again, I would first of all like to extend my condolences for your bereavement. Sorry, I mean, take heart in the law, and I hope the family, be able to get strength and move on. Have a sympathy again. Thank you.
Thank you so much.
Yeah, my name is Kunkunyon Wleh. Um, I am a Liberian Antonin. I practice law in Liberia. I do both civil and criminal practice, criminal defense practice because I don't work for government. And I also teach at one of the universities there, the African Mental Day at Zion University, where I teach in the Department of Public Administration and the Criminal Justice Department. So that's just me.
Thank you so much. And if you can sit up, please, and let's face the camera. My audience, they want to look in your face. The one
Yeah, I
in
mean, we got
Nigeria.
to manage it because there's a cell phone and I'm using my
Right.
hands to hold it.
Oh,
So,
okay.
yeah.
All right. So first, issue that we want to know about yesterday, we heard that Council Justice, Associate Justice Kabina Janet has been impeached. Walk us through the issue. What was the issue with Kabina Janet? And then let's dive into the process. For a lot of us who have not been following, just woke up and heard that the Associate Justice has been impeached. What was the issue? What was the process like? And just walk us through what happened.
Well, I haven't followed it in detail to the extent of reading all the records, all the documents in the entire proceedings. But interestingly, I think I have some fair appreciation, of the issues involved. So basically, I believe they had several counts against the justice, and amongst all, they accused him for misconduct. And one of those counts was that he bought a property, from you know a lady's son, one Constant, in 1996, and as a result, I think it's alleged that the son was not the proper owner of the property, and he had only had the decree of sale. He never had letter of administration, and there was some irregularity in the change of title. And he bought it in 1996, but then remember he was not a justice on the Supreme Court bench, not a judge. So I understand he became justice after after the war, the wife of the late Constant, who she by law who has priority to inherit her husband's estate, um, sought to claim the property, and she was on the property anyway. And then he filed in judgment to have her ousted, to have her removed from the property because remember I just told you that he bought the property and deed was issued to him in 1996. Okay, so in that case was going on while he was a justice on the Supreme Court bench. He hired his lawyer, she hired a lawyer, they went to court in the civil law court, and there was a default judgment. Default judgment is basically where default is nothing like default, where somebody did not appear, you have done something within certain time, you did not do it, and then they rule against you by default. Okay, so there was a default judgment against Man Constant, the Omar, and then her lawyer, exercised the right under the law to go up to the Supreme Court on appeal. And on appeal, I also believe there was no real contestation because there was some defect in filing the appeal on the part of her lawyer, and that appeal was dismissed. Okay, by the Supreme Court, the full bench, not by Justice Janet. Mind you, on the full bench, when that case actually went to the full bench, the entire Supreme Court to decide on appeal, he did not. I want to say that he did not sit on the case. He recused himself because he had interest in the matter. So the other four justices, excluding him, sat on the matter and they decided it. And the result of that adjudication was to dismiss the case. The dismissal of the case had the effect that Justice Janet won the case, and the other Man Constant ejected, they ousted her, they removed her from the property. So I'm also told that she is a resident in of District 8, where Honorable Akaras Gray is the current representative. And I want to believe that he had complaint from his constituent and he had to file this complaint onward to the House of Representatives, where they forward the matter to a committee that investigated, and that constituted one count of the bill of impeachment. And another count for which he was also subjected to the impeachment proceeding was the issue of road fund. Okay, the government of Liberia decided to tax, petroleum, import petroleum, or when you sell petroleum, they put certain tariff on a certain tax on it, right? So
Right.
whatever you buy, there will be some kind of percentage, I think 35%, where thing will go to the importer. I'm not too sure the figures, so forgive me on that. But I'm just giving you the gist and stain of the entire bit of impeachment. So some of that amount, I think 25% was supposed to go to government, and those who were actually selling the product was supposed to get 10%. Okay, so I think some of the importer collected those, monies, and to remit the part that was agreed upon to be given to government, some of them had problem to give it to government. I don't know where the real issues were, but it was centered around, government or the executive branch of government imposing taxes. And our constitution is clear as to which branch of government has the authority to tax.
Right.
It's just similar to that of the United States of America Constitution, that the Congress has the authority to levy taxes. Okay, so the same thing, the legislature in Liberia has the authority. So the importer, I believe, they raised those contention for which they withheld or they delay or they neglected, to have paid the percentage that was supposed to be remitted to the government. And they went on prohibition. Prohibition is a relief, injunctive relief, or you call it remedial relief, where parties fight if you feel that your rights have been violated, where you go for relief, right? to stop the government or to stop the government actors from carrying on such or any illegal action against the party. So those petroleum importers or dealers sought relief through prohibition to the Supreme Court to stop the government from putting some amount of pressures or requesting them to pay that money, right?
So, and you said because the money was not levied by the legislators.
Basically, I think that was the contention. It was illegal for government to collect that tax, for the executive to impose tax and to collect that tax.
Okay.
That was their contention. Okay. So I don't want to go through the merit of that. I just want to tell you what constituted the bit of impeachment.
Yeah.
So the one first is my understanding, and because normally the Supreme Court can actually operate through the justices in chambers. Okay. You can just go to the Supreme Court, you'll file anything, the whole bench are here. You can have somebody who will preside in chamber, and then where you file all those, remedial rate, all those for relief. So, and they can do it rotationally, they can assign them rotationally, right? One justice will be there for this time, when the time finishes, another justice will be there. So when they first file, when the first set of petroleum dealer file to challenge the government action or the executive branch action, it was former Associate Justice Councillor Philip Banks who was in chambers. Okay. So he listened to the parties. He started the parties for conference. That's the procedure first of all before you issue the writ. You sack the parties for conference. They come there. You listen to them. What are the issues, right? Right. The issue of to issue prohibition is left with the sound discretion of the justice presiding. It is not mandatory. After listening to the party, the justice will decide whether to issue the writ or whether he would decline to issue the writ. And in this case, Mr. Justice Banks felt that it was prudent enough and he had basis for issuing a writ. So he exercised discretion and he issued the writ. When he issued the writ, I think before taking further action, right? Because the procedure is if you issue the writ, then you got to send citation to the party for the party to file their formal appearance. That they will file written document to come make arguments, right? Where they will cite all their laws. So, but before he did that, then his time in chamber had expired. It finished. So the next person who succeeded him was Justice Janet. Okay? So when Justice Janet took over as the presiding justice in chamber, another group of petroleum dealer filed similar prohibition with the same contention, similar contention before him. So we listen to his testimony, we listen to Philip Justice Banks. Justice Janet review that second set of petitions, right? And he looked at what his predecessor had done, right? He issued the writ again, similar thing what Philip Banks did. And then what he did, in his mind, because he believed that the issue that was raised, that it is the legislature that must levy tax, right? That's a constitutional provision. And the Supreme Court has a precedent. They have made that law for prudential reason, for prudence, that for if constitutional issues are raised, right, the justice in chamber should not delay, let him just forward the matter to the full bench to be able to decide, because our constitution says the Supreme Court shall be the final arbiter of all constitutional issues, right? It means, I mean, lawyers get different interpretation for that. They have interpreted the court rulings on this to be that the Supreme Court will hear constitutional issue, but that's not what it means. That's not what the constitution says. It's the final arbiter. It means they should have the final say on all constitutional dispute. Okay? So the prudence upon which the Supreme Court made that ruling was, after all, even any decision you made in chamber, we still have the final say, right? So it's not prudent enough to take it and waste. It will delay. We want speedy trial. So just send it to the full bench and let's decide this. You getting the point?
Right.
So Justice Janan, in his mind, felt or he knew or he decided that constitutional issue was raised. So he forwarded the entire matter to the full bench. But effectively, what it did was it put hold to any request or action that was taken by the government to prevail on those people to pay the money to government, right? It brought the party to status quo ante. Nothing will happen until the matter will be adjudicated, until the court hear the matter and decide the rights of the party. So effectively, it put hold to all the requests, to any pressure or any form or action that was taken by the government to make sure they collect that money. And this has been on for years, right? And the government felt they didn't the money and they felt they were deprived. But that was construed as what? Abuse of what? Office, misconduct. Yes. So they also made that one of the counts for the bill of impeachment and another count. Another count for which he was subjected to the impeachment.
Before you move forward, because he already forwarded that to the full bench.
Correct.
So who put it on hold? Was it him or the full bench?
Before you forward to the full bench, you have to issue the writ. But issuing the writ, the alternative prohibition, it means that you order all the parties to remain as a nobody should take action. So effectively, he put it on hold, pending the decision from the full bench. And in fact, I think this particular part of the bill of impeachment, this count, is very essential because, in fact, this is the count upon which he was found guilty. Okay? This is the point upon which he was found guilty because all the other counts, they have full count, they acquitted him on all but just one. And this was the count. So it's crucial. So if you have any questions, anybody will have any question that I can further make, clarification on this. So the point is, to continue with this, he forwarded to the full bench, but before the full bench had called the parties or had assigned the matter to adjudicate the dispute or to resolve the matter, to hear it, the parties decided to go all by themselves, agree that they will withdraw it, they were going to do settlement. Okay? And in our court, like in any common law jurisdiction, the court always encourage parties to resolve their dispute. Okay? Because what it does, it reduces, the longevity, the time as to resolving the dispute in court. It also saves costs for the party, even for government, and it also gives other people the opportunity to have access to the court so their matters can be here. So the court, for public policy reason, the court encourage parties to be able to resolve. So the parties in this case decided, look, you know what, we can go out of court, let's withdraw this and have this resolved by ourselves. We need no judicial pronouncement on this subject. So the parties withdrew the contestation that they had before the Supreme Court. Okay? But it took time before the judge, I think more than 2 years or 3 years. I can't remember the exact time. But this is the whole thing that's surrounding this count as to. But mind you, one key thing I want to point out, one of the importers who have filed the petition before Justice Janet, Shimex. Shimex is a company owned by one Mr. Musa Belete. Okay? Mr. Musa Belete, I want to believe, is a very close friend and kinsman to that of Janet. So this probably may be the reason why people construe it to be that his decision wasn't independent. It was made based on connection or relationship to Mr. Belete. So people thought it was abuse or misconduct. But mind you, previous justice, the one he succeeded at, made similar decision for different parties before he even came on the same subject and questions. Okay? And one thing I also want to stress is our Constitution protects what we call, it gives judges and justices what we call judicial immunity. Just as here they say the House of Representatives and the Senate of the lawmakers. Anything you say intimate, you can be protected. Nobody should hold you for it. You have that immunity, right? That's the same with judges. They have certain immunity. You can't punish them for the ruling they make or for decisions that they actually perfected in exercise of their judicial function. You can't punish them for that. That immunity is in the Constitution. Okay? Except you can prove gross misconduct, bribery, you have to prove it. Judicial immunity is very strong because the framework of the Constitution always, and the intention is we must have an independent judiciary.
Right.
Okay? So if you start punishing judges for how they rule or how they interpret laws, then you know the court is just nothing but charade. So that's why they were inclined, our forefathers, and they gave judges, not just justices or not just the chief, but all those who are judicial officers exercising or adjudicating people's rights. They gave them that immunity. Okay, so the question as to whether you can now punish him for the decision he rendered as a judge or as a justice, then where is his immunity? Well, we gotta debate that every day and anytime. But that's particular subject constituted one of the counts for which he was subjected to the impeachment process. And in fact, this was the count upon which he was impeached. And another count was the charging for theft of records. Theft of records. So when the house, when the complaints were filed to the House of Representatives, right? The House were conducting investigation, they were conducting hearings. So according to the House, the managers or the bill of impeachment, he had a record from the House of Representatives, their minutes that they, according to them, that they did not publish. According to them, was a confidential record. And when he filed, mind you, when they started to go through this prohibition thing, the first thing he did through his lawyer, he tried to challenge them to prohibit them from not continuing with the prohibition, right? So while filing that prohibition, what he did was he attached the minutes of the House's proceedings to a prohibition to show that there was a hearing going on, they were discussing about impeaching him. So that means, they said that means it was in a public document. He didn't make official request for it. He stole it. So they also charged him for theft of records. That was another count in the bill of impeachment. All in all, he was acquitted on theft of record. He was acquitted on the one of the inconstant case, but he was found guilty by 22 voted for. That is, he was guilty for the road fund case, and 4 said he was not guilty, and I think 22, 4, 6, 3 acquitted. They abstained. They did not vote.
Yes. So that was the issue, and that's why he was impeached.
Yes.
What was the impeachment process like, or what should it be like? What was done? Just walk us through it and see whether they were within the confines of the law or not.
Basically, let's come back to small elementary civics or constitutional law. Okay? The constitution that we have, the constitution tells us how our government should look. It tells us how power should be allocated to the branches of government. It tells us where are the boundaries where one government cannot cross to go in another space. It tells us where one branch of government or another branch of government can have the power to call another branch to a check, right? Now you hear the word check and balances, where you try to check power in order to bring about balance in government for the smooth operation of a Republican form of government. Republican form of government, it means 3 branches of government separate equal but as you call it for the functional of the whole, right? So why do I say this? Impeachment in itself is a check mechanism on, in the instant case, on the judiciary. It is a check mechanism on the judiciary. What do I mean? So, judges, because again, we want them to be free, we want them to be independent, we don't want them to be easily influenced in making a decision. So, Technically, we gave them some long time of service. You gotta be judge to be judge in Liberia. You gotta serve up to 70 years once you have good conduct. Okay, 70 years. So if you lucky, you're 25 and made judge, you'll be able to get 70 years before you move there. Because we want to make you worry about your job. You know, we want that independence. We always want that in our system. So, but even though we gave you that independence, so it means that we gave you cash blank. We gave you that blank check. That because you gotta be 70 years, you get so the check mechanism is the one way we can check judges or can make them to be remanded that there's a power somewhere that can call them to hurt is impeachment. So impeachment is the power of the legislature to check the judiciary. Does that make sense? The power that the legislature has to check the judiciary. If the grows say, hey, no way you come here. Don't do this. They have many check mechanisms, but impeachment is one of the check mechanisms.
Okay.
Of course, the judiciary also has a check mechanism to also check. Mind you, all the branches can check one another.
Right.
Okay. The judiciary can also check the legislature when they make laws that are not consistent with the constitution.
Right.
When those laws are challenged, the judiciary, the Supreme Court can declare it unconstitutional. That's a check on the legislature. I give you one example. We talk about 2000 and was that 11 when Mill Jones wanted to run, right?
Right.
The legislature made law that was targeting the central bank governor because they felt probably he was doing something that was so political. So they targeted him. And when they challenged it, the Supreme Court, the judiciary came and said, no, the law is unconstitutional. It was checked. Hmm?
Right.
That's check. That's check power. So in essence, impeachment is a checking power that the legislature has over the judiciary, right? Not just only over they also do have impeachment authority, check power over the executive as well, because they can impeach the president, right? But in the
Right.
case, let's talk about impeachment as to the what judiciary.
Yeah.
So yes, and the Constitution gave the legislature the sole authority to exercise this power. Mind you, unlike the judiciary, the legislature and the executive are political branches. Okay? They are concerned more with politics and policy decisions.
Right.
Right? So, in most cases, you hear people talk political question, you hear that doctrine. That the political question is on what we call non-justiciable doctrine. That was coined when it said non-justiciable, which means it's a doctrine that the court would use to decide, say, we can hear this. Where the court can excuse itself for not getting involved in certain dispute, right? One, for many reasons. One, it could because that dispute would be a political question. Maybe when they say political question, it means that that dispute is something that is not, judicially, resolvable. You can resolve it through judicial means, right? You have no judicial resolution.
Right.
It's a political question. So even when the court here, the court can give you relief. They have real solution to it. They can resolve it. So the court would not like to embarrass itself to get in political activities where one lawmaker two more the fighting between bank, it will demean the court. It will demean the court. So this doctrine derived from the case Marbury versus Madison, a United States Supreme Court case, right? That the Supreme Court coined this doctrine to say, look, you know what? The thing about commissioning Madison or Marbury, we don't want to put it's a political thing, right? If we do it, we impound the court. So when you read the Marbury, you can Google it, you can see the brief, you know what I'm talking about. So basically, the United States Supreme Court coined that. But in 1986, when we drafted our new constitution, we inserted it in what? Our constitution, right? The thing about judicial review. Judicial review. Another case I talk about, I'm sorry, well, judicial review actually came from Marbury versus Madison, and political question came from a case, a United States Supreme Court case called Carr versus Baker, right? But we have adopted this maxim in our cases, in our jurisdiction through a lot of cases. So it is a recognized principle in Liberian jurisprudence that the court will not involve itself in any matter that is non-judicially resolvable, that has no judicial resolution. If it is a political question, so impeachment is a political question.
Okay. Yeah.
It is a political question. It means that the court would not like to get in impeachment business. So with Justice Daniel Farr, his prohibition, right? Even though the court did not make that pronouncement, but the court apply other non-justiciable. I'm sorry, I'm talking real constitutional law. So my audience,
Go ahead.
yeah, the court apply other non-justiciable doctrine. They get standing, they get reptness, they get mootness. So in that case, the first thing the court apply the issue of reptness. The first prohibition Janet filed to the Supreme Court. The court say, you know what? But you suffer no injury yet. You're discussing the thing, they investigating. Then you won't can say, what you suffer? What you hear? It ain't rep here. Janet was only repping the tree. Just think about that common sense, right?
Yeah.
So the thing it ain't rep here to complain. You suffer nothing yet. They recall you yet. They do nothing to you. Then you can't complain. So the court apply that non-justiciable doctrine and say that we can get anything, man, not rep. I had the court dismiss or they declined to issue the first writ of prohibition against the house.
Right.
But however, I don't want to go through all those details, the procedure details. Yeah, I don't want to go through. But let me just make bold statements. Yes, the legislature can impeach. They have the authority to impeach. The Constitution is clear that the bill of impeachment should derive from the lower house. Yes, the lower house can draw the bill of impeachment as it did. The bill of impeachment is just nothing but what? Allegations.
Yeah.
It's nothing but just allegations. Allegations. It's just like it's synonymous to an indictment. When they indict you, they mean you're guilty. They're just accusing you, right? They gotta take that indictment, bring evidence, documentary and testimonial evidence, carry it to court to prove it against you. The same thing. With the House of Representatives, draw the bill of impeachment against you. They indict you, they accuse you. They have to carry it to the Senate, who will serve as the trial body, right? Where evidence will be adduced, and then where they will make a decision to prove their allegations against you. So yes, the court cannot get itself involved in political questions, issues like impeachment. Oh yes, the legislature has authority to impeach. Okay, but however, when you are subjecting a person who has a privilege, who has a right, to impeachment proceeding, even though the court will not get involved in it, but the court will be concerned that you must give him due process. Right? So they will not mean the court and saying don't carry impeachment. They say you can do your impeachment, but all we know, there's certain guidelines you must go by. Right? You must give him the opportunity to be heard. You must give him the opportunity to be represented by lawyer. You should have rules that are fair. You can't be in the middle of the game, then you make rules in the middle of the game. That's not due process. The forum should be competent. The Chief Justice shall preserve all those procedural things that affect substantive rights. The court must be concerned to make sure they safeguard the process. Just put the man in the line, give him all his rights, and then you carry him, do anything he won't do. So, of course, even though the court cannot stop political question, the court cannot be involved in impeachment, but the court has a duty to make sure.
Right. To guide the process.
To guide the process. That your right must be according to you, consistent with Article 20A, and rules that are laid down or rules that are passed or promulgated must be adhered to. So if you violate that, the court can declare the entire proceeding as what being unconstitutional. Right? Yes, because you must accord the man due process. It's very fundamental. So if you see the people that were conducting the trial, they were cross-examining, doing all the things, they were giving him the opportunity to confront the people who accuse him. He had lawyers representing him, all the kind of things were just in satisfaction of his due process right. Yes. Even though along the way, I personally monitor the trial. especially at crucial stages, I think there was some major breaches. I think there was some major breaches as to according him his due process right.
Okay.
Yes.
Namely?
For example, first of all, Article 43 of the Constitution is clear, right? Article 43 says the rules governing impeachment proceeding. That rule means you must know the rule first before you go to the game. You can't be in the game, they draw rules, right? Fair, because our same constitution it prohibits ex post facto laws. Ex post facto law means you can't make law to punish things that already happened, right? So because I see Dennis does something, then I can't make law, so I'll punish you. Eh? We should make law that not even thinking about the other you're going to punish. The law should be made before. I hope I'm making sense. How are you getting me?
I'm getting you.
Correct. So the rules of the game should be laid and we should know it. But again, the Constitution requires that it said the legislature shall pass this rule. And in our form of government, when we say the legislature, it means what? The House of Senate and the House of what? Representative. The legislature does not mean one of the two. It means all two.
Right.
You can only have legislative action unless the both houses act, and there must be what we call concurrence. Void of that, one house action is not legislative action.
Right.
Okay, so the lower house passed rule, that the Senate did not concur with. When they reached the Senate passed their own rule that the lower house did not concur with. So I believe that violates Article 43 of the Constitution that requires there should be rules governing the entire impeachment proceeding that should be passed by the legislature.
Okay, hold on right there. Let me read Article 43 from this book. The power to prepare a bill of impeachment is vested solely in the House of Representatives, and the power to try all impeachment is vested solely in the Senate. When the president, vice president, or an associate justice is to be tried, the chief justice shall preside. When the chief justice or a judge of a subordinate court of record is to be tried, the president of the Senate shall preside. No person shall be impeached but by the concurrence of 2/3 of the total membership of the Senate. Judgments in such cases shall not extend beyond removal from office and disqualification to hold public office in the Republic, but the party may be tried at law for the same offense. The legislature shall prescribe the procedure for impeachment proceedings, which shall be in conformity with the requirements of due process of law. So you are saying those laws were not done by both, or the procedure.
The legislature shall pass the rules for procedure. The legislature, read the last sentence. Read again. Yeah. That's the point I'm making.
The legislature shall prescribe the procedure for impeachment proceedings, which shall be in conformity with the requirement of due process of law.
Correct.
So what you say in this case, it was only the House that did it.
Yes, there was no concurrence for any rule that governed the entire impeachment proceeding.
Okay, that's one. What's the next one?
Yes. So I think that was a serious constitutional violation that nobody should have ignored. The thing that I want to say is, well, no time. So let me just brush it up because yes. So another thing is another error I think is key. Let's deal with Article 43 first. Okay. Let's deal with Article 43. Okay, I want to go bit by bit, but it will take long because the way I want to draft through it, let's take time. So in the same Article 43, it says the Chief Justice shall preside over the proceedings, right?
Yeah.
Okay. I just want to point out the flaws. You asked me for what are the errors. The Chief Justice on yesterday, he commenced the proceeding. Final arguments were made. The parties rested. Right? He submitted the case to the senators to make a decision. The Chief Justice adjourned the proceeding. we may say today end, right?
Right.
While the procedure was adjourned to be resumed the next day, the senators voted. Right?
Right.
So do you think the chief justice were presiding when they voted?
Well, the power to do that voting reside with the Senate, and this is a political issue, right?
But the Constitution says the chief justice shall preside over the procedure.
The proceeding
preside
finished.
over the proceedings. Okay?
Right.
So the power to vote or to make that decision is part of the proceedings.
Okay.
Have you been to court before? When you make a case and you submit your case to the jurors, when the court can say, we're going with your juror, will come out tomorrow?
No.
You'll be in the court. The court has to be in session and they'll go in the deliberation room and then they will come out. The court still has to be in session.
Right.
Okay? So, in fact, this is key. It appears to be just technical argument, but it's key because if you listen to the objections from Justice Jennings' lawyers, they were raising the issue of irregularities and some kind of suspicious thing as to the way the vote was conducted. Right? I guess most all watch it or will listen to it. Because the way the manner in form about which the procedure was actually handled, the chief justice adjourned it. The senator went home and they voted in there at night on their own. It creates real reasonable ground for suspicion. And I think it's valid. That's a valid argument because he should have presided over every aspect of the proceeding, including for the senator to make that decision. He's not going to decide for them. He's not going to question it, but there must be some organization,
right,
some
oversight,
sanity, some oversight. Be there and let them make the decision. Right? Even in court, when the jurors go in the deliberation room to make that decision, the judges don't go there. But at least they know they are in court and all the parties are there and they're waiting. So you get the point I'm making? But you can't adjourn the proceeding, which means everything ends. They go and they vote in there. They will hear people say the owner is pro tempore carry the ballot box to a house. That is irregularity. It's wrong. It violates the spirit and intent of the Constitution that requires the Chief Justice to preside over the impeachment proceedings.
So, Attorney, normally yes, before the Chief Justice or the judge always will guide the jurors on how to vote, and what to do. Was that done also? Because they are going home. So as they were going home, did he give them what needs to be done during the voting process?
Again, when you listen to the objection to I'll take my time to listen to the crucial part. In fact, they have procedure. Another time I talk about the procedure. Even the so-called procedure they have in place that the one who passed. In fact, that's why I refer to it as so-called, because there was no procedure that made concurrence on a patrol that had bicameral backing. That procedure, they said the chief and the pro tempore shall make the form and each senator should sign their name, write their name, and sign their signature in front with a quote. They didn't go by all that. They didn't go by the rules. So they changed the rules in the middle of the game. They didn't go by the rules. The rule requires them to do specific thing and they did another thing. Okay? It all happened because the question you asked, the chief justice should have looked at what the rules and gave them the instructions while he's presiding, and they should make the decision. Okay? Right. But you just let me say, okay, we'll come out tomorrow, say no, bring a vote for tomorrow, 12 o'clock. We come out, bring it by say, why is the verdict? Now get it. Hey, you see the reasonable basis for people to make arguments, oh, they're cheating. So assuming the senators are, don't get me wrong, they are honorable people. They are honorable people. Let's agree that what came out is actually their vote. But you create ground for people to suspect it. You create ground for people to think that it's fraudulent. Okay?
Good.
So I think that was an error. It violates the Constitution in all regards. Another thing, there are a lot of things. Another thing, I want to do Article 43. Okay. Article 43, please read what the punishment is. What you say about the punishment?
The punishment for
after you shall be impeached, what is the punishment? I mean, I know. I don't want for the audience, for our audience.
Yeah, I'm trying to find it.
Yeah.
It
should be the third sentence.
Or the third sentence is when the president, no person shall be impeached but by the concurrence of 2/3 of the total membership of the sentence. Judgment in such cases shall not extend beyond removal from office and disqualification to hold public office in the republic.
Hold it there. Let me analyze that for you.
Okay.
Does that mean judgment means the person shall be removed from office?
No, it says shall not extend beyond removal from office.
Extend beyond. Okay.
Right. But so it means removal from office is part of it. But you can go.
Yes, but at the maximum. Let me put it another way that would be common for our audience. They say if you commit murder, it's life imprisonment or death, right?
Right.
The maximum. They say the maximum punishment is life imprisonment or death. That's the maximum. Right. So they say, should I extend beyond? It means removal from office is the maximum.
Right.
You understand what I'm saying?
Right.
So if you commit murder, they can sentence you for 50 years, 30 years. Right. But the maximum is life imprisonment.
Right.
So the analogy I'm trying to make here, they say the punishment shall not go beyond removal from office, right?
Yeah.
So you agree with me? You can suspend.
Yeah, you can.
Read the Constitution.
But that's not impeachment if you suspend.
No. That's impeachment. You know what is impeachment? The punishment itself is different from the impeachment.
Okay.
Okay. The punishment itself, because when the House passed the bill and they vote on it, you are impeached. Bill Clinton was impeached.
Yeah.
Because they did not convict him, so there was no punishment given to him. So when the House of Representatives passed the bill impeachment against Janet, of course Janet was impeached. Okay, but from what we saw today, when they came out with the verdict, he was impeached and convicted. Right?
Right.
So after being convicted, he had to face punishment, and the punishment said he should not go beyond what? Removal from office.
Removal. Right.
Okay. So the young king, when you read, I listened to them because I've been taking notes on that because I'm planning to write an article on this, as I've always been doing, on critical issues like this, because I have my graduate studies in tailored toward constitutional law, so I have interest in these subjects. So I'm waiting to hear that. And then when the king said, "Oh, so fine, get it on this count." So yeah, but we the punishment is consistent with Article 43. It means nothing. So you tell him you can be Article 43. It don't tell you what is the punishment. They tell you what is the maximum punishment. So you should decide what is the punishment. It's vague.
Right.
Read Article 43 again.
Before you continue, so what does impeachment mean?
Impeachment, you say what does impeachment means?
Yeah.
I just explained to you. When you pass the bill of impeachment in the law, the person has been impeached.
Okay, hold on 1 second. We have a caller on the line.
Okay, yeah.
Hello, caller. Your name and where you calling from?
I'm calling from Pennsylvania.
You can hear the caller, Anthony?
I'm hearing the caller.
All right.
Yeah, I can hear you.
Okay, Faleku, welcome to Focus on Liberia. Your question or comment, please.
Thank you very much.
Go ahead with your question or comment.
Hello?
Yes, Faleku, go ahead with your question or comment.
Yeah, the guest is still talking.
No, go ahead. He's not talking now. He's listening.
Okay, yeah, so I'm calling from Pennsylvania, USA.
Your question or comment, please.
Okay, my question is, okay, I heard you clearly, Anthony. Thank you very much for the, yeah, there's a question.
Go ahead.
Yeah, there's a question.
Go ahead, please.
Okay, so the attorney said the court, hello?
Hello, go ahead, Faleku, we're listening.
Yes, so the attorney said the court doesn't battle with political issues.
Faleku,
So
Oh,
Yeah,
yeah.
it's a political process that's going on now. That, going on in the legislature, in the House of Senate.
Okay.
Okay, but then they are violating the Constitution.
All right. Attorney, you mentioned that this is a political issue which the court doesn't like to battle with. I think you explained that, but Faleku is asking if that's the case, then they are violating the Constitution. Or what does that explain again? What does that mean when you say the legislature or the court does not want to battle with political questions, but they can guide the process?
First of all, let me say that. Hello?
Yes, we hear you.
The political question doctrine is for the court. I hear people apply it in all kinds of ways. The political question doctrine is for the court. That's the court tools. For lack of better word, that's the tool the court can use as an excuse, right? Not to be involved in certain dispute. That the court will feel there is no judicial resolution. It will bring embarrassment to the court. It will bring embarrassment to another branch of government. It will bring more confusion, right? The court can use that own to say, you know what, it's a political question. We don't want to get involved in it, right? But however, if you're doing political question, if the Constitution requires you to accord certain rights, that in the instant case, they say you must give him due process, right? And you read the rules, you read to go for the last sentence.
Right.
Say the rules of procedure shall be consistent with due process.
Correct.
So it requires them. So even though the impeachment is going on, the court will say it's a political question that they don't want to get involved in it, but that is not an excuse to violate people's substantive right.
Correct.
That is not an excuse to violate the substantive rights of individuals. You must give them due process. But the court only telling you that, no, you know what, the thing, if we get in there, you're going to drag the court in a mud. You're going to bring embarrassment to the court. The thing will get in, we can't even resolve it. And if we have time, I will explain to tell you how this is not, there's no judicial resolution to this question. But it's complex, it's classical constitutional law that I don't want to delve into. I know I have some audience who will understand what I'm talking about, but it is a political question, but that is not elections to give the body that is actually adjudicating the impeachment proceeding to violate the substantive right of individuals.
Thank you. Faleku, I hope that answers your question if you're listening. If not, you can go back on Facebook and then ask a question. There's a question here on Facebook from Dave Jar. It said, is there any precedence of this sort of impeachment involving two separate branches of government?
Not I know of, but I read about the Chipo thing, but I didn't think it actually escalated to this level where there was a full-blown trial and there is a verdict or decision from the Senate. I understand that Chipo resigned and those say people went to file a resolution and say you are impeached. But there was no real full trial where people had an opportunity to go and do like a court-like proceedings. So we had the Chipo case, yeah.
Okay, so just go over again as a part B to this question. What is the ground for the legislative impeachment?
The ground for the legislative impeachment, misconduct, breach of duty, treason. There are a lot of grounds. They are spelled out in the Constitution. But for Janan, they carry him for this particular impeachment. He was accused for misconduct.
All right. There's a comment here from Fidel C.T. Buri from London. He said impeachment is a process used by the legislature to charge public officials. It is a statement of charges, not a verdict. It does not necessarily have to result in a removal from office. Kunkunyon covered that very well. That's a pat on your back.
No, but I think I said that, right?
Yeah, that's what he's saying. You cover it very well.
Yeah. So impeachment is just all allegations, just like indictment. Yeah, sure, definitely. You are correct. Yeah.
Okay, so Justice Janan was removed from office, which is the punishment.
Well, I don't know whether he was removed from office. Again, I think there's a technical legal argument I'm making because I don't know whether he was removed from office. They just say we bring a decision consistent with Article 43.
43.
Article 43 only tells you that the maximum punishment for those, the maximum judgment shall not go beyond removal.
Removal.
Right? So
right.
What it means, the person is he can do many things. So all they're telling you, they mean just put it in another way. You have an apple, you get oranges, they get banana, they eat your monthly, everything in the house, your monthly Noah. You can eat all the things there. But the rest should be the last thing you touch.
Mm-hmm.
And their master punish you and carry you. Eat something there. You understand it? So you can eat anything.
Right.
So I think the verdict, if I will call it verdict, like a proper war from the Senate today, I think it was vague. It should have been very specific and particular as to what the punishment they were giving Justice Janet.
That's fair. So what's the next plan of action? Can this be appealed or where else?
Impeachment is, again, it is not appealable because mind you, the court will always not let you get into it. But however, you can challenge it. You can challenge it. Impeachment, it can be challenged only as not the verdict. Okay? But you can challenge it as to the violation of substantive rules. For example, if they have a rule to say this is the rule that will govern the impeachment proceedings, right? And they ignore the rule, they violate the rule, and they hamper your rights, your fundamental right. Because let me tell you something, fundamental right can never be raised. It can never be waived. Substantive rights can never be waived. So Justice Janet may go to the court, and file some kind of challenge to say, you know what, they didn't give me due process. Because mind you, the Constitution requires what? Due process, right? It does not mean you appealing from the appeal. You can't appeal for it. The judgment of the Senate is final, but the effect of that appeal, as they will say, okay, you'll carry. We say, I'm going to do your impeachment, but you'll get a due process. But in this case, to be fair, I don't know whether the Supreme Court now would be, inclined to accept such a thing, but they may do that, where it's glaring that we know now, maybe they just didn't get fair and say, because anybody can be subjected to impeachment too. So I don't know whether they'll be brave, but anybody can do it. I mean, it depends. They have the right, they have the power, and they can decide whether they can determine whether a due process right was violated, but they cannot reverse. They have no power, as appellate forum to decide impeachment proceeding. No, they don't. It's not appealable, it's final. You can read the hello? Hello?
There's a comment from Facebook talking about the Senate or the Representative Rule 63 and 66. Steve Walton says Rule 66 and 63 are rules that lay down for only the House of Representatives and the Senate, not for people outside the House of Representatives. I don't know much about those rules, but
no, I don't know what you're talking about. I know Rule 63 was rule that was actually passed and meant for impeachment. Okay, yes, Rule 63 from the Senate was actually rule that were passed and meant to govern the impeachment proceedings. It's not for rules governing the House of Representatives. It's for impeachment, Rule 63.
Okay.
So I hope he will check his facts right, and probably he will see.
I think that's the same thing he's saying, that this rule only applies to the House, not people outside. But okay, another follow-up from Faleku, who was on the line. He said, you said all the counts were dropped except the count about the taxation of petroleum product. He took that decision when he was adjusted. So why was he impeached for that?
Well, that's a good question. Your guess is as good as mine. Kaleku, your guess is as good as mine. Why? Because I talked about judicial immunity, right? Where you don't punish judges because of decision they render. Of course, that's a good argument that he may make. But again, but mind you, judicial immunity is not carte blanche. If you're exercising your function as a judge or justice, the Constitution requires don't abuse it. So maybe the people gave evidence that the senator were convinced that he abused it. There was a misconduct. Maybe they found misconduct in exercising that function as a judge. Okay? Because you get immunity, you can do misconduct in exercise of your function. So maybe the evidence the people adduced, the senators were convinced that there was a misconduct. So in their wisdom, calling the house of elders or the wise men, right? I heard them calling the wise men. They felt that there was a misconduct. So they what they said. In fact, that was the very said. They said we found misconduct. We found misconduct. We found misconduct. They said that.
So, ladies and gentlemen, if you just joined us, this is Focus on Liberia. We are broadcasting from Atlanta, Georgia. We are discussing the current legal issues in Liberia. At the top of those issues is the impeachment of Justice Kabina Janen. Our guest tonight is Attorney Kunkunyon Wleh. He's an executive member of the Liberia National Bar Association. So, and our lines are open 706-684-0392. You can call us at that number, that is 706-684-0392, and be part of the discussion. So moving on along, and we will always come back to the Justice Jana case, but let me ask you this about the, I introduced you as an executive member of the Liberia Bar Association. What is that, and what is the role of the LBNA in the practice of law in Liberia? Because something I'm getting at is the current president or head of that is Councilor Tiawon Gongro, and he says something about the Supreme Court. So let's go to the role of the LB, the Liberia National Bar Association.
Well, I am an executive council member. So they have the executive committee and they have the executive council, right? The executive committee is the highest body. I mean, comprising of the president, the vice president, the secretary, and the treasurer, right? So those executive officers, they also have executive committee members who make decisions. You know, so we all go to elections, we won the elections, and we won. So I'm a part of the executive council of the Liberia National Bar Association. So far, the youngest ever in the country history. Probably somebody gonna come and challenge that record. But basically, the Liberia National Bar is an association of lawyers. You know, the Bar Association, you know, has so many responsibilities and obligations to society. It was established by act of the legislature as an association with small group of lawyers, and very, very small group of lawyers. Not even more than 40 in the whole country. We don't have more than 40 lawyers, you know.
Oh, wow.
Yeah. So, and it was actually meant to seek the welfare of lawyers and to see how best they can aid the court in regulating the practice of law, to make sure, you know, lawyers come in association, lawyers are governed by codes, you know, lawyers are responsible in the practice, you know. But over time, the Bar Association rule has expanded, you know, where the bar is generally referred to as the General Council of Society, you know, where the bar sometimes the bars do, you know, the bar do legal aid programs. We run up, you know, services for indigents, you know. We have programs all over the country. We work with a lot of US, you know, projects like the US Embassy. They support the bar very well. So we render services to indigent poor people in criminal cases, especially criminal cases. And the bar also is involved in advocacy as well.
Just hold your thought. Just hold your thoughts. Hello, let's focus on Liberia.
How you doing, guys?
I'm doing good. Your name and where you calling from?
Yeah, my name is Andrew Boyle, and I'm calling from Boston, Massachusetts.
Okay, Ansu, welcome to Focus on Liberia. Your question or comment?
My question is for the guy in the studio. I do understand there are certain requirements that must be met before an impeachment hearing is brought before the Senate. Those requirements were not met. I'm not a lawyer. How can it be possible to go ahead when you haven't met the initial requirements? Not to you specifically, but to speak on the issue as it was. Because I'm a little bit confused. I'll give you an example. If a person is going to be tried for a felony, he or she must commit a felonious act, correct?
Correct. Go ahead.
Okay, I said before something can happen, one thing must happen before another thing happen.
Right.
In terms of the impeachment, my thing is, Kabina Jana was not tried for any crime. I don't like the man himself. I really don't believe he should be in the Supreme Court. He must follow the laws properly. Now, I believe speaking from a layman point of view, like I said, I'm not a lawyer, how can it be possible to remove a Supreme Court justice when you haven't met the initial requirements that are required in order to remove that person?
When you say the requirements were not met, what are you specifically talking about?
Okay, this is what I'm saying. Before a person can be removed from the Supreme Court bench, he or she must be tried and convicted of certain crimes previously. Okay, it must be tried by a court of law, and there was no court that tried him that convicted him. So now, according to Justice Banks and these scholars are actually testifying the case, the initial requirements were not met for the removal of Justice Janet.
Thank you.
So how can it be possible to remove it when you haven't met the initial requirements?
Attorney Tan, your response.
I think I know. I mean, I didn't understand the entire question, especially from the beginning.
No,
but when you talk about trial, hello.
No, what he's saying is, he said before a person can be removed.
No, I gotta just a minute, Julius. Dennis. I think I understand the question when he talks about trial. Okay.
Okay.
So there's a provision in the Constitution that says proof misconduct. That's what the caller is referring to. Proof. They said it should be proof for proof misconduct. You understand it? So
right.
The argument have been, hello?
Go ahead.
The argument have been, and I hope the caller is listening. I don't know whether he's still on the line, but probably he can listen to us. The argument have been in this, the point, they said you can impeach for proof misconduct, right? So Justice Janet Tim had argued, and this is not the first argument that any body or any team that had been in defense of an impeachment have made. Similar argument have been made in the United States and in other jurisdictions. We always say that United States because our country is a common law country, and most of our law are modeled after the United States. So I always say that, and they have a lot of precedents on these subjects, right? The Nixon case and other cases, Bill Clinton, and you can name them, Johnson case. So the issue of proof misconduct. People argue that there must be proof. People argue that proof misconduct means, right? There must be some kind of investigation, criminal investigation, the person charged and convicted, right? For that conduct or for that act. Then it means that conduct was actually proven. After that, that's the only time you can proceed to impeach him for that conduct. Am I clear?
Yeah.
That's the point he's making. There must be some kind of process through whether it's a criminal investigation that will result to conviction. Then it means a proof. The conduct is proven. Before you can proceed to have him, impeached.
Okay.
Others argue that even if the conduct is not a crime, within the judiciary, they have what we call the Judiciary Inquiry Committee, right? That investigate judges and judicial officers, judges and justices, right?
Right.
They say if it is not a crime, you should submit the person for that misconduct to the Judiciary Inquiry Committee that will conduct investigation, and there must be some kind of finding, holding the person liable, right? Then it means that conduct is proven. So people argue that that's the only two bases upon which you can impeach somebody where the Constitution says prove misconduct. Prove misconduct. So they said because they said Justice Janet did this, he did that, he did this. You didn't prosecute him for they say theft of records, right? They said you carry him to justice ministry to prosecute him to prove that he actually stole for it to constitute impeachable offense. They say you say he stole a woman's land, he did blah blah blah. You didn't carry the Judiciary Inquiry Committee to show that he had a misconduct, to prove the misconduct. So without proving it through the bodies, then which means there's no impeachable offense. I think that's the question the court is asking. I try to take my time to explain it, right? But however, I think to do that or to go with that line of reasoning, in my mind, it will violate a fundamental principle of our Constitution, the separation of powers. Okay? Because doing that, effectively, it will mean that for the legislature to carry on their express or their enumerated power, it should be condition. There should be a condition precedent. That is, there must be the executive must act for by prosecuting a man, right? Or the judiciary should investigate man first. So when the executive not act, the women the legislature can carry on their function. So when the executive not act, when the judiciary not act through the judicial inquiry committee, which means the legislature cannot carry on their function. No, but the constitution did not condition their exercise of impeachment power on any other act.
Right.
Okay? So you'll be making a handicap in doing that work. So you so you get the president who like, no, that's not the intent of the constitution. So let me explain when I say proof misconduct what it means. Right? So that's why the House of Representatives were under charge. The bill in impeachment is only nothing but a charge. Yeah. Allegations. So you have to take that bill of impeachment that constitutes all the allegations of what? Misconduct, right?
Right.
And you carry it to the Senate to conduct what? Trial. And at that trial, what are you going to do there? To prove the misconduct.
Okay.
Does that make sense?
No, that makes sense.
When you bring the witnesses, you bring the document, and then you will prove it. It has to be proven.
Hold on. Ansu is calling back.
Okay.
Ansu,
Yeah, disconnected.
right, he's answering your question. Are you listening?
I'm listening.
Okay, go ahead. All right.
Okay.
I'm putting you on while he explains.
At the Senate, there where you are required in the impeachment proceedings to what? To prove the misconduct. That's why in this case that we all witnessed in our lifetime, Justice Janet had witnesses. He brought documents. He had the opportunity to cross-examine or to test the inclination or credibility of the adversary witnesses. And the Senate felt that the misconduct was what? Proven. Right? They felt that the managers or the House of Representatives proved misconduct, and they brought the decision on that count that it was proven. So they felt that the other counts, for the one for the inconstant case, the one for the theft of record, they felt that it wasn't proven. So he was not convicted or punished for that. So it was proven that there was a misconduct as to the exercise of the discretion in issuing the writ of prohibition.
Thank you. So, Ansu, there you have it, or the attorney is saying if we want one group to prove it in court first, then it means the action of one body is predicated upon or dependent upon the action of the other. So the proof of that misconduct was done during the hearing, and the Senate believed that it was they have proof enough. So thank you for the call, and we can. So let's move on to and we can always come back to the Justice Janet issue.
Yeah, that's okay. I know that they had this thing. So the issue of the bar. So the bar also engaged in, we make pronouncement, we give opinions, we review Supreme Court opinions, we make pronouncement on certain issues that have legal implications. Not necessarily that we just there to be doing advocacy, but we are the general counsel, so we lead the society on difficult or controversial legal questions. Okay, so that is the bar. Whenever you have lawyers, we have welfare programs for lawyers, especially aging and sick lawyers, and we have lawyers paid due. We go to conventions. At conventions or assembly, we review. We do law reviews. We invite experts in different field to come and give their opinions as to how our jurisprudence or our jurisdiction should grow. So the bar is just an association of lawyers, and they do a lot of things, many things we do.
Okay.
In essence of improving the practice of law in Liberia.
The current president of the Liberia National Bar Association is Councilor Tiawan Gonglo. Just around the time of this case, I think he cautioned the Supreme Court you know, like in fact, to the extent of saying that the war that happened in Liberia, because certain things were not done right, because if our judicial system is not strong, and I think many people have even pointed to that, that if the judicial system is not, because there was those lapses, which some refer to as institutional failures, that's why we had a war. But your law group had an issue with the councilor's accession.
It's funny, you know. Well, I don't know. I conflicted on the matter, right? As a member of the executive council, and then my partner, in fact, Councilor Masakwa, is no. Again, let me make the clarification. Councilor Masakwa criticizing our position or his view on the subject was his view. That was not the view of the international law group.
Okay.
Okay. So they only say Councilor General Masakwa of international law group. I think you read that article. So that was his personal view. All lawyers at the international law group having their views and and perspective on different legal issues. Okay. So I do not agree with him. Hello. Okay.
Yeah, but just give us a summary of what Councilor Gonglo said.
No, but this is very crucial. I gotta lay it first because I'm from the international law group. I'm from the bar, so okay. I can't be there. My law friend criticize the bar and on executive committee. Let me make that very clear. So that was Councilor Mazukwa's position, right?
Right.
First of all, it's good the way you ask the question, like you even know the answer. And I agree and I support the statement or the response that was given by Councilor Gongo, and I disagree with Councilor Masakwa. I told him, we argue that. He has a view. Gonglo is correct. Gonglo responded as a president of the bar because the Chief Justice had mentioned the issue of the response of the impeachment proceedings in his address during the opening of the Supreme Court. And Gonglo responded, and he cited history. He referred to the Chia Chipo incident, right? 1987. Yeah. You know, Julius, or people who listen to know how Chia Chipo left the Supreme Court. And when it happened in 87, in the way the government then, or the way the court were actually influenced then, so the independence of the judiciary at that time, although it was questioned. Is that secret? So people never have confidence in the judiciary because people fear even if, especially political opponents, they fear even if you go to the court or not, that court, they were doing taking charge people from there, they hide people. That people go there, no, they even give you no justice. So if people start having that feeling in any society, right, they will result to something else that we experienced in 1989. Okay? So all what Gonglo was saying and what he meant was in difficult times, like what we just mentioned, or the times that we have now, the court should try to maintain its independence so it can have the confidence of the society. So people can feel that the court is that place you can go to get solution if you have problem. Because if people feel like that, then they will find or they will be compelled to use alternative means to give themselves relief.
Right.
And that's how the court appeared in the 80s. That made people like Ellen, and you can name all of them who came here. They ran away and they came here because they couldn't go through any kind of process in Liberia then. So they found other means that they're going to go back. And that war and that other means actually caused the death of over 250,000 persons. Is that wrong? Isn't that true? Isn't that true? Of course it's true. You quiet and I take a silence to be, yes, you agree with me. It's true.
Oh, that was my question. I thought it was rhetorical.
Yeah, it's true. So,
okay.
So the point is, the court should maintain a standard. Be void of all the confusion between the political branches. Let people have confidence in you. So even if the opposition, if ANC or CDC or whoever opposition or whatever get confusion, they can be confident enough to say we're going to that court. They will hear us.
Yeah. And
But
justice
if
is
they don't,
blind.
yeah, if they
So,
don't, of course, no matter what waste the time to carry anything to the court.
okay. Dede, not Dede. Fidelity Booty pointed us to Article 71, which
Okay.
because there were other questions about the ground for impeachment.
Yeah.
Article 71 reads, the Chief Justice and Associate Justices of the Supreme Court and the judges of subordinate courts of record shall hold office during good behavior. They may be removed upon impeachment and conviction by the legislature based on proved misconduct, gross breach of duty, inability to perform the functions of the office, or conviction in the court of law for treason, bribery, or other infamous crimes. I know you covered that. I just wanted to read that based on what
Yeah. Yeah. I told
Mr.
you
Budi.
it's spelled out in detail in the Constitution.
All right. One last thing, because I know our time is fast spent, but one last thing I want to for you to walk us through is the executive request to repeal the Tenure Act. Before President Sirleaf left office, there were some tenure jobs. When President Weah came to office, there was talk about requesting for those tenure jobs to be repealed or those acts to be repealed or terminated.
Yeah.
What's the legal thing concerning this tenure job and how can they be repealed?
Well, I just want not to just we can have a very long view and different arguments on them. But let me just throw it out, right?
Mhm.
I told you from the beginning our constitution divide the way power should be assigned to the different branches of government, right? So they give the executive their power, they give the legislature their power, they give the judiciary their power. Okay? So the legislature in Liberia, for example, comprises of 103 persons, 30 senators, 73 representatives. They can't do all the work that they have power to do, that the constitution gives them. They alone are able to do it. Hmm? They're supposed to make law for taxes. They're supposed to a lot of things. They have a lot of things to do. Plenty of work. Hmm? They can make law. They can do this. They can do that. So, for example, so because the legislature can do everything, that's 73% can do everything. And if there's certain work they are required to do that requires certain expertise, it's more past budget, right? Just think about it. You need to get good financial background. You know, some point in that house, not only library, even here, some point in the house here, they don't get financial background. Not everybody get all background. So you need some kind of professional backing to make certain critical decisions. So that's why in constitutional law permits what we call administrative law, right? Administrative law is where, but that because the legislature can exercise all their function effectively, they can what do they can do delegation of function. They can give some of their power to agencies. They create agencies to act on their behalf. The agency, I mean, we say agency, you're an agent in principle, right? Now you get a meeting, you're acting for me. We are agency, that why I'm creating agency. The same thing, the same type of model in America here. You get it here. So they create administrative agencies and they delegated some of their powers to them to do, especially in specialized areas. For example, the legislators want to make laws, but the lawmakers may not be so inclined or they may not have the expertise to pass laws on telecommunication. You need people
Okay.
who work. Hello?
Please hold your thought right there. Let me get a caller on the line.
Okay.
He's calling from Great Britain, so I want to give him a chance.
Okay.
Mr. Fidel C.T. Budi, you are live.
Thank you, Dennis. Thank you very much. Well, first of all, I want to thank our brother, Councillor Ted, for his comments tonight. I think he's helped me personally to understand the entire process and how it's gone on, where the feelings were. I do have a question to ask, and it's kind of linked to the comments he made about the historic events that happened in 1987 with Chiajibo and how that kind of undermined the independence and credibility of our judiciary system. And the suggestion I picked from there is that he believed that something similar might happen, or that is what the president of the bar was suggesting might happen if this impeachment, which we all feel was politically motivated, it went ahead. But my question is, if we have this separation of powers and the legislature has an expressed responsibility within the Constitution to be the one that can impeach people, what could the judiciary have done? What were their options, or what was their option in terms of averting what happened today? So is there, or was there anything that the judiciary could have done given the fact that the legislature has that expressed power as is enshrined in our Constitution?
Thank you. We'll give the attorney a chance to answer.
Beautiful question. That question is a brilliant question. But let me say this. I don't want to be too academic. You know, I'm a constitutional law lecturer. So you see, more like I'm a lecturer. I asked my brother to go and Google the case McBarry versus Madison. I refer to it initially. Let me give the history about that case. I'm not going through all the facts, but in that case, there was a question submitted to the United States Supreme Court to decide as to whether, because a previous, I don't get all the names right as to the president, but the president who was leaving appointed somebody to take a position, right? But the president was confirmed, I think he didn't give the commission, and the next president came, he don't wanted to give the man a commission to take office. So the man challenged him, went for McDonald's to compel him to have him installed in office, right? So when he went to the court, to the Supreme Court of the United States, Chief Justice Marshall, you know what he did? You know what he did? That beautiful question he asked. I don't want to give you the example now, but bringing in a Liberian context. That's a very good question. Chief Justice Marshall, what he did, he answered all the, because first of all, the government challenged that separation of power. The executive has the authority to decide who works in the executive. That is not for the Supreme Court or the judiciary to interfere. They raise all the beautiful argument in front of the Supreme Court. So the Supreme Court heard it. So the Supreme Court, but Chief Justice Marshall, no, what he decided to do before deciding jurisdiction, let me say that no matter what courts do, before court hear any dispute, before they decide to hear any dispute, the court must first establish its jurisdiction. They must decide whether they get the power to hear that matter, right? And most often when the court first decide that question and the answer is no, we don't have power to hear this matter, the court will dismiss it. But when that question was presented before the United States Supreme Court, Chief Justice Marshall felt there were other key questions that was good for the society that the court needed to make clarity, that the court needed to make pronouncement on in order to avoid future embarrassment and confusion. So what he did, he answered the question for jurisdiction last, in our opinion, right? He put it last. Then he answered all the other ones and he said, okay, the Supreme Court has the authority of judicial review over other branches of government. He made a lot of pronouncements. Then in the end, he said, as to jurisdiction, this thing is a political question, so we can hear it and they dismiss it. Let me tell you what I mean by that. In fact, even though the court did not give, Madison the relief he wanted, right? Marbury the relief he wanted, but the court make pronouncement that live on. And today, the principle of judicial review is very key and cardinal in the United States of America. That pronouncement. What do I mean put in Liberian scenario? He said what the Supreme Court could have done, even though they gave the legislature the power to do impeachment. But what the court could have done in the case to actually help the situation, I think that's the question, right? When they filed Janet filed the prohibition first, or when the court has so many prohibitions before it, because remind you, there were 4 senators who also filed prohibition, including Dana Nathan, Comey Wleh, TJ, and somebody else, and Oscar Cooper. So they raised issues. What I expected the court to have done was, number one, first of all, the issue, the court want to interpret what is meant by impeachable offense. So up to now in Liberia, we have no interpretation as to what is impeachable offense. It just left like that. The court did not answer that question. I don't think the Supreme Court did all justice. They raised the issue as to Article 43, whether there should be concurrence, as to making the rules governing impeachment. The court did not answer that question. They didn't give the constitutional meaning. They didn't interpret it. All the court did, you know what? You don't get no standing with this nails it. In my mind, if the court would have interpreted the constitution, those provisions, the issue of what constitutes proof misconduct, the issue of what constitutes impeachable offense, the issue of what constitutes the rules, then by now all the things are resolved. So tomorrow it will have impeachment classes. The same thing that will come out again, Julius. The same thing, all the dispute, it will cut up. The issue of rules, the issue of what constitutes proof misconduct, people will make the same argument because why? The Supreme Court that has the authority to interpret the Constitution failed. It failed. So in my mind, it will have resolved most of the contentious things. It will going to give the Constitution meaning, those provisions meaning by interpreting them. I hope I answered the brother question.
Thank you. Let's conclude on that. Yeah, I think you answered it because. Okay, let's conclude on the terminal acts that you were explaining, so that we can close the broadcast.
So, because the legislature cannot do all the work, all the power to do, so they delegate some of their functions to the agencies, right? But there are two kinds of agencies. They having administrative agents, they having autonomous agency, and they having executive agency. Autonomous agency means the agency should be what? Independent. Which means they should be void of political control. And in constitutional law and administrative law, the reason why you have independent agency is that those agencies actually exercising generally legislative or judicial functions, right? So to allow the executive to have control over agencies that exercising legislative or judicial function, it will violate the principle of separation of power. Because the president only have an executive function, the executive only gets executive function. So for what do I mean? Like the GAC, like the LACC, this investigative body for corruption. Generally, these functions are for the legislature. Arguably, we may say to fight corruption is a crime is for the executive. But on the issue of integrity, that's something that must have exclusion of what? Political control. It should be void of political control. The president should just get power to call the LCC boss. Okay, you know what? Investigate one. You know what? Don't investigate one. So, in my mind, of course, those agencies that are exercising judicial function or executive function, or officers that are exercising judicial function or legislative function, the president should not exercise political control over those agencies or officers. To do that, it will violate the principle of separation of powers. But those agencies that are exercising purely executive function, of course, you can stop the president from controlling executive function agency. He should. So to pass law to prohibit the president from exercising control over those officers, also you'll be violating the separation of power. And you'll be usurping the function of the executive officer of the executive. So my recommendation, in fact, I appeared before the House's Committee on Judiciary on this subject, and I recommended that there was a need to assess all the agencies on a case-by-case basis. For example, lottery authority, what they need to get, lottery authority don't need no independence. A purely executive, you can stop the president from removing somebody who lottery director. What kind of independence you need to do lottery? But the GAC needs independence. The LACC needs independence. You get that? So it should have been done on a case-by-case basis. You can just kind of brush all the training from everybody. You can't do that.
So which, in your view, which of the tenures should stand? Which one should go?
I can't remember all. Like GAC should remain. In fact, GAC is provided by Constitution. Like the LACC should have tenure. It should have independence. But again, don't get me wrong. If you read my article, tenure does the Constitution only calls for what? Independence.
Right.
It only calls for independence. So tenure does not necessarily mean independence.
That was my question I was about to ask.
Tenure does not necessarily mean independence. Okay? But conventionally, right? The best way that an officer or institution can maintain independence is to give him tenure or to give them tenure. Huh?
Right.
Because there are many ways the executive can influence officers, even with tenure. For example, they can influence them through the budget control. The man will not give you plenty of money. See, he like you get a tenure, just sit down there, okay, with time a allotment, we don't give you money, just make you useless. So they can stay exercise control over you that way. When you want more money, you start, I mean, I don't know, dining with the man, you have no independence. So there are many ways that the president is so powerful, so there are many ways they can stay exercise that control, but at least the tenure is a better security. So conventionally, even in the United States, I see there are some agencies, you see people decide for tenure.
So what was the final decision on the executive request
Well,
for
I
the
think
tenure?
the House, the House of Representatives, I think they passed it. They agree with the executive bill, but they gave minor amendment. They only gave the GSC tenure. They gave the GSC. They gave the Elections Commission tenure. Of course, the Election Commission should have tenure, and they gave the CSA tenure, but they took away tenure from the LACC. But when we reached the Senate, I think the Senate disagreed with it. The Senate sent it back. So that bill it had not passed the entire legislature. It stayed before the Senate, or I think the Senate conference room.
All right. So our time is fast spent. I want us to go back to the general issues so that you can conclude and give us your final thoughts.
Well, if you say, I mean, I believe, well, the legislature had authority to conduct the impeachment proceeding. Is a check mechanism that they must exercise on the other branches, including the judiciary. So yes, I mean, they could have exercised that power, to on any judge, not just Janet, But I think the manner in form in which it was conducted, it appears to be more like it was targeting. That's my opinion. And I don't think they accorded him due process as the way the rules that govern the proceeding, it was actually promulgated. It didn't mean to tear, sorry, not to tear, it didn't mean concurrence of the both houses. And the manner in which they even conducted the vote. You adjourn the proceeding, they go home, and they bring the ballot by the next day, so we finish voting. I mean, it's baloney. It doesn't make sense in any civilized democracy, And we all, it happened. Again, we say that political process, we do everything. But what hurts is we make laws, we have laws, and we bury the laws, and we all just pretend like everything is okay. That is the sick thing for any society to do. We all want to emulate America. Every day we want American people to help us. We want other countries to help us. These countries are better because they respect the rule of law. America, yeah, Donald Trump, president, they subjected him to a screening process for 2 years. 2 years. Criminal investigation. The rule of law is key. It's key for the survival or advancement of any society. So if in Liberia, if we make our constitution, we just bury it, and we all just put our heads in the air and be acting there's nothing wrong with that. We gotta think. It's sad. And we talk about the economy is bad in Liberia. Okay. I recommended to a lot of economists why they want to do all their math from central bank. The first thing we should start from, we should make business people to have confidence in the judiciary. We should make investors to have confidence in our judicial process. If they don't have confidence in that, they will not do business there. Because if you businessman, somebody owe you money, for example, you go to the court, that case will spend 5 years, 6 years, 7 years. What kind of businessman will be in that? So the speeded adjudication of matters is also good for the economy. It's good for business. It's good for investors. So from the legal side, from the judicial side, that's something we should concentrate on. We should make the code to function. It should work. And if business people as well feel that the code there is no independence, of course, nobody want to go do business in that type of environment. Especially someone who get good money, they don't want to get their money in place that is classified as corrupt place to get their money dirty. Because we take clean money carry there, we get dirty. So we will make the code to work. The code should be able to give people relief very quickly. It will help the economy, and then they can think about all the other math and economic theory. But you do all the theory and the code not functioning, forget the business pool, they're not going to invest a lot in that country. So we all got to work hard, leverage for us all, and we got to think positively about ourselves in our country. I mean, I have nothing much to say, and thank you for hosting me.
Thank you so much for coming. As you can see from the comments and questions, most of my audience, they're very impressed that people get to know what they didn't know about this case before. Because we see what we try to do is we all have our opinions, but we always want to have someone who knows a little more or who has that expertise to come and educate us, to help us, so as to understand these issues, and then we're able to make informed criticism, judgment, or opinions. So thank you so much for coming. I know you'll soon be returning to the soil. We want to say bon voyage. God bless you again for. And if you are in Liberia, don't forget to tune in to Focus on Liberia. Here we try to educate, elevate, and promote all things Liberia. To our guests across the globe, we want to say thank you also for joining. It's been a pleasure understanding this case. And if we have time, please go on Facebook and respond to some of the questions and comments at your leisure.
Thank you, Mr. Jar. I appreciate it as well.
From all of us here at Focus on Liberia, including my co-host Danielle Knuckles-Guishard and my guest relations manager Stephanie Setro, we say thank you so much. This Sunday, we're going to talk about sanitation in Liberia, especially Monrovia and its environs. Someone said Monrovia is buried in trash. What can we do about this trash issue, the garbage collection? Someone who has the expertise and who have been working in that area is going to come here and tell us about how those waste materials can turn into gold, as he said. You don't want to miss that, Sunday at 6 p.m. Eastern here on Focus on Liberia. Until then, from me to you, my name is Dennis Jackson. So long.